Hello everyone and welcome. My name is Claire Barcham. I'm a senior officer at ADASS and I focus on policy and practice. I'm joined by Lorraine Currie, who works in the West Midlands and is an expert around deprivation of liberty safeguards and LPS. Lorraine, tell us more about yourself.
Yeah, so hi everyone. I'm an associate member for West Midlands ADASS, focusing entirely on MCA, DoLS, LPS issues. Prior to that, I was a DoLS lead in a council in the West Midlands. I also do freelance MCA and DoLS training, and previously chaired the regional and national DoLS leads group. I've often been called the Mary Berry of DoLS, but it's not very flattering, really.
But well earned, definitely.
Yeah.
Now, could you give us a bit of an introduction to last week's case, what it was about, and who was involved?
Yeah, I'll try. It was a very unique case, and I think it sort of was a bit like a snowball. It gathered as it went along. So usually a case gets to the Supreme Court and it's got a person at the heart of it or people, and it's been heard in the lower courts, and then they've disagreed and been appealed, and then eventually it may get to the Supreme Court. This case did not have a person at the heart of it. It was a devolution issue. It was brought by the Attorney General for Northern Ireland, and their question to the court was whether they could introduce, through guidance in their code of practice, a new way of describing valid consent. Certainly a different way than it's understood and utilised in DoLS currently in England and Wales. So essentially, it was a policy question. So it was a hearing about a policy question. Can they describe valid consent as something which, in the absence of capacity for care and health decisions, could a person still give valid consent? Could that be inferred or understood from their wishes and feelings? So they wanted the court to look at that, and the outcome would be that their code was still Article 5 compliant, but differed significantly from the way it's approached in England and Wales. And then as it went along, other people kind of thought, oh, this has got wider implications than just a devolved issue for Northern Ireland. So Scotland were represented, Wales. Then the interveners were the Health and Social Care Minister, and various charities also got to join to the proceedings and to put their views.
Now, I know it'll be 6 months before we get a response, a formal response from the court, but what is the possible implications of this case?
Yeah, so I think as everybody started to sort of think about and then get engaged with, it's really got quite far-reaching implications, because if that was the case for Northern Ireland, then it would be the case that we could interpret the DoLS or whatever they're replaced with. We could interpret them in the same way in England and Wales. So if you can imagine, at the moment we've got 350,000 applications for DoLS, which we're not able to process because there's far too many. That's just through the DoLS scheme. And then we've got others going to court. If some of those people could potentially be considered to be giving valid consent, because well, it's more than the fact that they don't object, but they certainly don't object, but they give some sort of positive affirmation of being content with where they're living and the arrangements that amount to confinement, then they would no longer be within Article 5 and would no longer need the protection of the safeguards. So you can see that that's got positives and negatives, which obviously engage the charities, but it would have the impact of reducing numbers.
So something that could be of great interest to a lot of directors and PSWs across the country, that the actual number of people coming through the DoLS system or the LPS system in the future could drop significantly.
Yeah. Yeah, it would engage them, I think, in two ways. One, the numbers would drop, but also how do we test that? Or how do
Right.
we work out valid consent? As a PSW, as a director responsible for people making these decisions, there's going to be a lot of thought needed if this case is successful. So, Claire, you and I watched quite a lot of the 3-day hearing. How did you find it as an observer?
I thought it was really interesting. I mean, obviously it was great also to be part of a WhatsApp group. I hadn't realised there were 150 people on there, Lorraine. That was a lot of
Yeah,
people. There were
yeah,
barristers,
yeah.
there were family members, there were all sorts of people who had an interest in this case, commenting on what had happened. I found it really interesting realizing that the judges may come to this case without knowing a huge amount about the law. So they're really going to have to update themselves about what the case was about, why it's important. And I thought it was really interesting the approach that different people took. So as you said, you had um, the people from Northern Ireland explaining why they thought it should be possible to change the guidance so that people without capacity or who lacked capacity could still indicate their own views on that and that be taken into account. Equally, you had people from the charities who were quite passionately saying that they were concerned about the safeguards and people losing safeguards of somebody independent coming out and um, seeing what was happening to them in their placements. So I can see this is going to be a really interesting case to keep track of. And I don't know about you, but I don't know which way the judge is going to go with that.
No, no, absolutely. You could sense a little bit from them, certainly some of them, that there was a willingness to look at a way of overturning elements of Cheshire West.
Yeah,
You kind of got a sense of that they would like to do that to narrow the scope if they could. But that didn't represent them all, and that doesn't mean that they'll find a way of reopening that in their discussions. I don't think you can call it. No, I think it'll be watch this space till next spring, really.
yes. And I suppose the other thing that occurred to me is that that will fit in quite nicely with the announcements around the liberty protection safeguards and the government giving itself 6 months um, before it needs to consult on the code of practice for LPS, because I think they'll want to know what the outcome of this court case is and make sure that the code of practice complies with it before they actually bring that out and give it to us for consultation.